My name is Cesar Pereira. It's a pleasure to welcome you to the fourth session of Ciarb Branch Time. This is an initiative organized by the Chartered Institute of Arbitrators with the support of Arbitration Channel to bring together some of our 44 branches all around the world to discuss some of their commonalities, some of their differences regarding many important topics in international dispute resolution. And today, we are very honored to have here with us the branches of Scotland, Ireland, Kenya, and the Thames Valley in the UK, together with the Uganda chapter, which is for a very little, for a very short time, is still a chapter of the Kenya branch, but we expect Uganda to become a branch very shortly. And the topic we would like to discuss with representatives from all these branches is related to construction adjudication. As you may know, the Chartered Institute of Arbitrators has around 18,000 members all around the world in 150 jurisdictions. 55% of those professional members are not lawyers or not only lawyers. And we have many engineers, architects, quantity surveyors, and we have had in these 111 years of history very strong connection with construction law, construction practice, and especially with construction adjudication. If you take a look at our website, among the 29 protocols, guidelines that Ciarb has issued, 5 of them are specifically related to construction adjudication. And so it's a very important part of what Ciarb does, and we are happy to be able to discuss that topic with some of the jurisdictions that do practice construction adjudication in their contractual practice. For that purpose, we have here with us a very important group of specialists in that field. We have James Richardson, who is a director of the J. Richardson Consulting Limited in the UK, representing the Thames Valley branch. Also, Kirsten Beckett, who is an independent dispute resolution consultant in the UK, also from the Thames Valley branch. We have Professor Kenneth Wyne Mutuma, who is a chartered arbitrator and a fellow, and he is with Wyne and Associates in Nairobi, Kenya, and he's also chair of the Ciarb Kenya branch. We have Kenneth Akampurira, who is the Ciarb honorary secretary of the Uganda chapter. Paul Karekezi, Paul Karekezi, who is the executive chairman of GIB Africa Limited in Kenya, and he is also a member of the FIDIC presidential panel of dispute board members, and we will discuss that topic specifically with Paul very much. We have Professor Brandon Malone, who is a fellow of the Chartered Institute, an independent arbitrator and adjudicator, and until recently was the chair of the Scottish branch of Ciarb. And Corrinne McLeish, who is also a fellow and director of HKA and a quantum one expert witness in Scotland or from Scotland. And she illustrates the point that I was making before about the the range of professionals that are covered by the Chartered Institute of Arbitrators. And last but not least, we have Dermot Durack from the Irish branch, and who is also a chartered quantity surveyor. And but and I understand he's also been a barrister for a long time. So with this amazing group of speakers, we will be able to cover a large range of issues relating to construction adjudication. And I would like to start with you, James. I, um, I understand in the UK you have a system of a statutory construction adjudication, but also adjudication that can be based on contractual provisions. And I think it's always a point of doubt. What is the specific effect, a specific force of an adjudication decision? Is it like a temporary binding decision? Can it be considered a de facto final determination of a certain issue? So if you could please explain a little about how construction adjudication works in the UK and these effects, it would be very important for our audience. Thank you. James, the floor is yours.
Thank you very much, and it would be my absolute pleasure to do so. We've got some of my slides on the screen now, and exactly as you say, we're going to look at whether an adjudicator's decision is temporarily binding or whether it can be de facto a final determination. And just to give that background, exactly as you were indicating there, within the UK, we've got the Housing Grants, Construction and Regeneration Act, which gives us the statutory framework for adjudication. And we've had that since 96, coming into force in 98. So it's something that's been around with us for a really long time here. It's something that's really embedded itself within the construction industry and has become a mainstay of how we resolve disputes. Just having a quick look at that statutory background, and section 108.3 is the provision which discusses the binding nature of an adjudicator's decision. And it says that a construction contract shall provide that the decision of an adjudicator is binding until, and the until is until the dispute is finally determined either by legal proceedings, arbitration or settlement. And we don't tend to see contractual provisions that go beyond this. This tends to be the framework within which contractual provisions operate, and it's a temporarily binding decision, but there's that opportunity to go on and to have it litigated or arbitrated depending on your provisions in the contract. That said, we tend to find that there's a high proportion of construction disputes that never go on to be finally determined. And here we're looking at some research done by King's College London back in 2024. They did several of these papers. And one of the questions they asked their respondents, and it's probably the most wide-ranging research, certainly in the UK, that we've had recently on construction adjudication. And what we found is 52% of respondents said that in the past 5 years, none of their adjudication disputes have gone on to be referred to either litigation or arbitration. And a further 18% say that it's happened less than 5% of the occasions in which they've had adjudications. And if we take the bottom two, well, the 31 to 50% or more than 50%, only 5% of respondents to this research were saying that more than a third of their adjudications go on to be finally determined, which I think we might draw a distinction with dispute boards and other mechanisms of alternative dispute resolution, where it can sometimes be seen as a dress rehearsal for the arbitration or dress rehearsal for the litigation. So in that context, I think there's a distinction there. And what I'm briefly going to try and touch on and maybe give a few answers to is why. I don't know, but I have some suggestions, one of which is confidence in the process. We're also going to have a quick discussion about the value of the disputes which we see referred to adjudication, and then some of the commercial and psychological reasons and realities behind parties' decisions. And then I'll leave us with a question if there might be something else going on that I don't quite understand and we might be able to discuss further. So the first point there was confidence in the process. And I've got a case here, McCobb, which is very familiar to anyone, certainly practicing in England and Wales and possibly Scotland. Our Scottish colleagues will tell me later, I'm sure. I believe it's relevant there as well. A very early case in which the courts enforced an adjudicator's decision. And it's very much in line with a whole trend or line of authority that we've had since the very earliest days of adjudication, in which the courts, particularly the High Court and the TCC, have said, we're going to enforce adjudicators' decisions, even if there's an error of fact or law, other than on very narrow grounds of jurisdictional challenges, we're going to enforce. But they've always done this on the basis that it's a temporary enforcement or it's temporarily binding with a final determination to come. But what it has done is enhance familiarity with the process. This slide and the next one are just designed to provide a bit of context as to what we've seen. And then I'm going to talk a little bit about the reasons why. And the first context we have for why adjudications might be the final determination is the value of disputes. And this is from the same research I was talking about earlier. And what you can see is that 53% of disputes referred to adjudication are for £500,000. And actually, it's only 2% that are for 5 million or greater. The second piece of context I would like to add is the timescales. And what you can see here is that adjudications are particularly quick. So 16% of adjudications are completed within 28 days. Up to 29 to 42 days, you've got 48%. And then near enough all of the remaining, a total of 96% of adjudications are concluded in under 76 days or 75 days and under. And I think that can really distinguish itself from litigation and arbitration, where you have considerably longer. I know from my work as an expert witness, when I'm doing litigation, I'm getting court dates that are 18, 24, 36 dates in 36 months in advance. You're not getting that same turnaround. So why might adjudicate? What might be the reasons that adjudication is de facto or so often finally determining disputes in the UK? Well, one reason I think is cash flow. I think that there's an amount of projects out there, or there's an amount of clients using adjudication who are really using it because of that speed that we saw on the last slide. It's the real attraction of adjudication. And actually, if you're a construction company with struggling cash flow, the idea that you might be getting a resolution in 18 months isn't really a great deal of help to you. It was really the purpose of adjudication to improve cash flow. And those timescales that we saw in that previous slide are doing that. And for the same reason of internal resource, do parties really wish to tie up their internal resource on disputes that are going to run for 2 years? You've got fee earning staff or people who could be managing projects, instead sitting in lawyers' offices going over past projects. There's a resistance to that. And because of that, I sort of concluded that I think there's a chunk of our clients, as an adjudicator, there's a chunk of our clients who would never really have considered litigation or perhaps even arbitration. There's a Coulson quote that I don't have here, but he says adjudication isn't an alternative to anything. For many, it's the only game in town. And I think that is right. I think for a lot of people, having a fast, efficient resolution and a cost-effective resolution is the only real game in town for them. We've also got costs, and costs, I've got two things that I'm bearing in mind here. The first is the cost of the parties incur in running their adjudication. And they're obviously substantially lower if you're running a 28-day 42-day, 75-day adjudication than it is to run a 3-year litigation. But you've also got the fact that in adjudication, you can't recover your costs. And therefore, you're not operating under the threat of the other side hitting you with their costs should you lose. So I think there's an opportunity to go to adjudication again, which when you're then, if you were to say lose and you're staring down the barrel of do I go to litigation or arbitration, it must weigh in your mind that you could eventually incur these additional costs from the other side. And then I've got a couple more which are sort of a bit more woolly, but one is you've had your day in court. And I think for a lot of people, it's very important to have your dispute heard and to feel that your submissions have been well considered. But that can be done by a high quality adjudicator in a very skillful way that allows people to understand that they've been heard and taken account of, but without having them necessarily get the answer they want. And for some, that's enough. And then finally, there's some commercial realities. One being you have a decision with which you can live and you think, well, I'm not happy, possibly the other side's not terribly happy. Let's all go home and get on with our lives as opposed to dragging this out. Or it may indeed stimulate a settlement because it's shifted that dynamic between the parties. It's perhaps unblocked something which will allow them to negotiate their way through. And then finally, I just want to talk about this case, which is BDW and Ardmore. Now, in this case, you had the parties entered into contract in 2002. The works were completed in 2004, and the dispute was not referred to adjudication until 2024. Now, I don't need to get into some of the local reasons why that was possible in terms of limitations, other than to say that we had a very tragic fire in the UK, Grenfell, and as a response to that and some of the defects in the buildings that caused that, we have new legislation called the Building Safety Act, which extends the limitation period on some of these claims. Now, in this adjudication, the adjudicator awarded or ordered payment of nearly £14.5 million, and that was enforced in the TCC, the Technology and Construction Division of the High Court. Now, why I want to make a point of this case is this is really not something that anyone had in mind being the job of adjudication when it was debated in Parliament in 95-6, passed in 96 and came into force in 98, so 26 years ago, 28 years ago, sorry. So what's going on? Parties have seemed to say, well, actually, we want to choose adjudication as our venue for this dispute resolution, even though we're not really using that vehicle for what it was designed. And in this case, there was disclosure, there was an extended period. In many ways, you could say, well, why didn't they choose an arbitration or litigation route? It would have been litigation in this case. And I think for some of the reasons that we've said before, but particularly confidence in the process and confidence in the dispute resolvers is what caused them to feel that they wanted to pick this venue for adjudication. And also the high speed, perhaps, or relative speed, even though it's not what we might associate as quick in terms of adjudication, it's certainly quicker than waiting for your chance in the High Court, shall we say. That's where I got to with my thoughts on this topic, Cesar, but perhaps I could pass it back or open the floor to anyone else.
Thank you, James. I was really curious about one thing. You mentioned that costs, if I understood correctly, costs in adjudication are not recovered
Yes.
from the other side as they would be in arbitration.
Yes.
As you said, that's good because it avoids that threat of being of having to pay costs. But on the other hand, it creates a burden, right, on the party that ultimately prevails. It cannot recover those costs. Can you tell us about something about the magnitude of those costs? How do they compare with the amounts in dispute? How do people deal with the fact that they cannot recover those costs?
Absolutely. I think one of the things that, again, adds some context is that what has developed is a situation where you don't necessarily have to be represented by legally qualified representatives in an adjudication. And you find a lot of people with quantity surveying backgrounds or construction backgrounds are now acting as adjudication party representatives. And then but whilst also having the solicitors. So what you've got is a very competitive market of people prepared to act as representatives in adjudication. And the way I would say is that there is an opportunity for whatever level your dispute is at to select an appropriate dispute party representative. So you still have, if I take the case of BDW and Ardmore at £14 million, you would have had two very high-end solicitors representing each side, and they may well have retained counsel. And that would be a significant cost. You're exactly right to say that would be a very significant cost. But perhaps reflective of the sums in dispute, right through to the other end of the spectrum, where perhaps you're arguing over £100,000, and you might have people who are prepared to offer fixed fees and more competitive rates. So in answer to your question, I think it is a burden. I think, you probably are looking at something in the range of 5-10% of the dispute value, even particularly at the lower end, could well be your representation costs that you're simply not going to recover. But I think parties accept that to have their opportunity at an adjudication where they perhaps otherwise wouldn't have had that opportunity.
Thank you. I don't want to compromise our time management here, so we'll come back to some of my other questions later. But I really want all of us to think about something that caught my attention when I attended the annual conference of the Dispute Review Board Foundation, the RBF, and which was the use of dispute boards for more than construction. And from what you are saying, the framework of adjudication is something that can be very useful in other industries as well, not only construction. But let's go back to that point later. And before that, I would like to turn to Kirsten. Kirsten, I understand you are an independent dispute resolution consultant also in the UK, and so I would like to hear you about the training for adjudicators, about the formation of adjudicators, and how the Thames Valley branch and how Ciarb generally deals with that idea of making this market open for new entrants, and how do we train our future adjudicators?
Thank you so much, Cesar, for the invitation to be part of this initiative today between the branches. I think it's a great idea. Great to be part of it. Hi, everyone. I'm Kirsten Beckett. I'm part of the committee of the Thames Valley branch, as Cesar mentioned, with James Richardson. We are a very dynamic branch, I will say. We offer a wide range of talks on various means of ADR. I'm a member of the Chartered Institute of Building, a fellow of the Chartered Institute of Arbitrators, and I'm also qualified as a non-practicing barrister in England and Wales. I spent the early part of my career working as a quantity surveyor for major UK contractors, and first came across adjudication quite early on, actually, early 2000s, and I was appointed as a party representative to one of the parties in a dispute. Since then, I have undertaken a wide range of dispute avoidance and also dispute resolution work for a wide range of clients here in the UK, including parties to adjudication. And if I could, I just wanted to start by offering one statistic. It's actually from the same report that James mentioned, the King's College report, which was produced in 2024. I think that was the last year it was produced, but hopefully there'll be more of those soon, because they were incredibly useful in giving statistics about what's happening here in the UK. The thing that struck out to me was that as at April 2024, there were 791 registrations for adjudicators in the UK. Now, that doesn't equate to the number of adjudicators, because obviously individuals would register with more than one panel, but it was the highest number of registrations in the 8 years to 2024. And I think what that upward trend shows is the real interest in construction professionals wanting to become construction adjudicators here in the UK. So it's something that I'm currently embarking on myself. So today I wanted to share my experience, what I've been finding, and with 3 particular points in mind. Firstly, what initiatives exist here in the UK for a construction professional who wants to become an adjudicator? And there are a number of those. Secondly, my own experience of pupilage, which I completed in December last year. And then thirdly, what are the next steps for me? How do I get onto a panel? What are the requirements? How do I get my first appointment as an adjudicator? So thinking about my first point, there are a number of initiatives available. I made the most of what was on offer, I have to say. In May 2024, I attended the launch of something called the New Practitioners Group, and that's an initiative which has been put forward by the Adjudication Society to support those who are in the early stages of their career as an adjudicator, or indeed to provide assistance for those who are undertaking the party representative role as well. So it's a really useful group. They meet, once or twice a month. They will have a social occasion. There will be education tips between people who are embarking on the career. And that I found that to be really useful. And whilst I was at the launch, there was another initiative offered that individuals could sign up to ad hoc or formal mentoring schemes. So what would happen is that a person wanting to become a construction adjudicator would shadow an adjudicator on a live matter and get that real sense of what the time pressures are like, what it's like to manage the parties in the early stages of the process, even down to communicating with the adjudicator nominating bodies regarding appointments, that kind of thing. So it gives the pupilage gives a whole range of experience. So that's something that I signed up for. And fortunately, what happens is you would specify what your experience is. So if you're an engineer wanting to get into adjudication, if you're a quantity surveyor wanting to take on the role, and then what happens is you are matched up with someone who has similar skills to you. So you get that, sort of more relevant experience, if you like, that's really tailored to your own particular path. And I found that experience to be so incredibly useful. When I embarked on it, I had thought that it would be all about decision writing. And obviously that's a huge part of it. But the part that I really enjoyed, actually more than I thought I would, is the communications with the parties. So what would happen is the adjudicator would be communicating with the parties, and then I would get those communications from the parties, and I would send my suggested response to the adjudicator, and we would compare notes as to approaches and suggestions regarding timetables, because even something simple can, as we know, end up becoming a bone of contention when you're in that sphere. So there are a number of initiatives. As I say, I've certainly made the most of them. And then what happens? So I shadowed my construction adjudicator on 3 separate matters. And once I had completed my decision on those, we would exchange documents and compare our different approaches to see what our decisions were, first of all, but also how we had come to those decisions, looking at all the documents and witness statements, that kind of thing. So yeah, it was a really useful insight into the workings of being a construction adjudicator. And so that now that I've experienced that, I'm now on my next step, if you like, as to perhaps getting onto a panel, and that brings me to my 3rd point, which is that in the UK, unless an adjudicator is named in a contract or the parties agree that particular person, then the approach would be for an adjudicator nominating body to appoint the individual to the dispute on the basis that they are able to hear that and have the skills to do that. And each panel has its own requirements for joining. As we know, for the Chartered Institute of Arbitrators, we have one needs to attend an interview and pass the interview. In order to get the interview, you need to be a fellow of the Chartered Institute of Arbitrators, and that can be done via 2 routes. Either by experienced practitioner, but also by qualification. So yeah, I'm currently looking at the different adjudicator nominating bodies, seeing what their requirements are for joining one of those, and then taking the next steps to getting onto a panel. But I know I've got very limited time today, but if anyone would like to, discuss that further, then I'd be more than happy to share my experience. As I say, it's one that I found really valuable, and it brought up things that I hadn't necessarily appreciated, even though I've dealt with adjudication matters for some time. So yeah, it was a very valuable process. But Cesar, just to touch on your point as well about the dispute boards and the transferable skills and transferring in, perhaps looking at different industries, not only construction. I mean, I don't know if you know about it, but there's a really interesting situation going on at the moment in Australia, and it relates to Brisbane 2032, the Olympic Games, which are going to be held there. And it is a dispute, as far as I can see, about the location of the Olympic Stadium in Victoria Park. And I know that dispute boards have worked really well in an Olympic setting. And what I've been wondering is, whether you could have a dispute board set up right from the beginning of a project, even before you've sort of started the construction work, where you're able to take into account and give decisions on matters as, the location of buildings, for example. That's something that's really sort of piqued my interest at the moment. I don't have any answers on it, unfortunately, because I've got limited experience of dispute boards, but I understand that they can be very effective in the right situation. Yeah. Thank you.
Thank you, Kirsten. Yeah, as you mentioned, the dispute boards have been very important for the London 2012 Olympics, in other projects as well. And in Brazil, where I'm from, when we had the 2016 Olympics, DRBF came to Brazil and helped set up a group of about 100 dispute board members who were available for all the projects that were involved in that big thing. One thing that happens in what's called these mega projects, and maybe we will touch on that point later, is that you can also have mega boards with like different types of expertise that will be following the project since the beginning, as you mentioned, and will be called upon to decide on specific issues like environmental issues, for instance, that not all members of that mega board would be familiar with, but some of them would, and would be called to discuss that specifically. So it's adjudication or dispute boards. This whole system of non-binding or non-automatically or finally binding decisions that are given by experts on a relatively short time frame, and then that can be challenged later, can be a very effective system. And I just wanted to comment on one thing that you mentioned about first appointments. And we do have a presidential panel of adjudicators at Ciarb. Each president over the term of 1 year must make about 100 appointments of adjudicators per year. And I think we will also discuss that later. Branches also make appointments and have their own systems for appointments. And so getting involved with the Chartered Institute and in complying with the requirements to join those panels, I think it is a very important step to get those first appointments and to be able to build a career. So do you have any thoughts on that?
Well, I have been thinking about it recently. I finished my pupilage in December last year, and I've been busy doing other things since then. But it's something that's definitely on my mind. And I obviously am part of the Thames Valley branch, and so yes, 100%. Top of the list. I'd like to be making steps towards becoming a panel member on the Ciarb. Yeah.
Wonderful. Thank you. We'll now thank you, Kirsten. We'll now change continents here, and as part of this discussion today stems from the fact that the UK originated construction adjudication model expanded for many other countries where that same tradition flourished, and one of them is Kenya. And I would like to turn now to Professor Kenneth Wyne Mutuma and ask him about the current state of adjudication in Kenya and maybe some comparison with what happens in other jurisdictions, and possibly following up on what Kirsten was talking about. What about the training mechanisms that Kenya branch has been using in that respect? Kenneth, please, the floor is yours.
Thank you very much, Cesar, and very, very good evening to all of you, depending on what part of the world you are. I imagine in Brazil, it might be early in the morning or somewhat midday. I'd like to convey first the apologies of Engineer Paul Karakezi. He's been taken ill suddenly. He sounded terribly like when we spoke earlier on. So he would have loved to join us, but hasn't been able to do that. So over to my reflections on the current state of adjudication in Kenya. I think the first observation is the interest of the region when it comes to infrastructure investments. So there's been a lot of infrastructure investments, roads, energy sector, water sector, and so forth. Some of these investments happen cross-border in the context of the investor-state relationships, or they may happen within state corporations. They've got different names in different parts of the world. The parastatals, the state-owned enterprises, and so forth. Adjudication would then, of course, pop up in essentially standard contracts in that specific context. A lot of those standard contracts are the FIDIC forms that we are more or less conversant with, and the different editions, the different colors for very specific kinds of projects and so forth. But we do have our own local forms, what we call the JBC contract, that operates with in the context of quite a number of domestic construction projects. What this essentially means is that, unlike the UK, adjudication in this part of the world tends to be still very contract-based. And I will speak about that when I come to training, because a lot of the programs, training programs that Ciarb Kenya branch does, Kirsten, you may have mentioned that earlier, and stem from a standardized curriculum based on the housing grants context in the UK. But the reality on the ground is that whenever you'd have adjudication as a mechanism, dispute mechanism, it would be contract-based. That means that we are currently trying, I think, part in the nature of reforms and rethinking how to make sure the true purpose is served in a local context. We are thinking around suitable training mechanisms, but I'll come back to that shortly. The other area, of course, when it comes to what's very unique in our jurisdiction is that we do have bills that are pending. They've been sponsored by the Nairobi Center of International Arbitration. They've gone through public participation and so forth. And so we're expecting an imminent legislative reform. One of those bills is the construction payments adjudication bill, and it draws inspiration from the housing grants bill, even though its scope is very much limited to questions around liability and payment, but it has very, very tight timelines, probably even tighter than in the UK. I think 14-day period, because the situation in Kenya is one where I think the biggest encumbrance and hindrance when it comes to resolution of disputes is the question of time, as specifically within the construction sector. Just to give you a sense of what that looks like in percentages. So a number of the appointments that we make as the Kenya branch, almost about 70% of those appointments will be construction related. And building up on this discussion that we're having, there is a feeling by many of the users that where litigation was yesterday, and that so pressing need for arbitration That picture has sort of been repeated in modern times, with arbitration being seen as a really slow, onerous process, fairly legalistic in terms of procedure, and the need to fast track the user's experience through adjudication in this large percentage of disputes that are construction related. So we're looking at a landmark shift where we may be moving from adjudication as a contractual privilege to it becoming a statutory right. So probably at this time next year, we may witness that huge shift, which will be very good for the various reasons my colleagues have spoken to earlier. Reasons relating to cash flow predominantly. So the bill is really being looked forward to. But with that, there are serious discussions, and we've had a few of these discussions on the side with you, Cesar, and a number of people on how to make sure that the Kenyan environment jurisdiction has the right number of practitioners to support this growing demand for adjudicators. So Ciarb's Kenya branch is at the center of that discussion with very important policy offices like the Attorney General and the Judiciary, the Chief Justice, on how to provide suitable training. I have written also to our colleagues in London just to find out what that would look like in terms of endorsement from a global reach. What that training is starting to suggest is that we need something beyond the FIDIC certified adjudicator program to something that is more located within local realities and something, of course, that is more strongly, rather more aligned to international realities. That would mean local case studies and so forth. But the recent developments, as you mentioned, with dispute review boards, and their emphasis on avoidance, DAABs, that's what we call them in this part of the world, drawing from the FIDIC language, is also finding its way into the kind of training needs that we would be looking at when we are growing this crop of adjudicators, so that it's not in the traditional sense that we've understood as adjudication as a post dispute process, but to incorporate what essentially have been considered contract, administration, management, governance, and risk issues, all packaged together as avoidance. So how to then have these three predominant qualities in the cohorts that will come out of the training, which essentially would be understanding the avoidance process, but also understanding the traditional adjudication process, what that process looks like, what a hearing looks like, and how that differs from arbitration. And then more importantly, just the role that a chair would play and the kind of decision writing skills that you need. So for first instance, what we've been doing is starting off very much like Kirsten said, with fellows who are arbitrators who are fellows as the initial fodder that would supply that capacity that the industry needs. And it's a very strong one. If you think about it, some of the policymakers in government essentially say they would have fast-tracked movement to the 2017 FIDIC edition, which makes a very strong call for the establishment of dispute avoidance and adjudication boards, with a major emphasis on avoidance, if they were certain that there was enough capacity in the region. So what has tended to happen in Kenya is a stagnation with the 1999 forms, purely because of the hesitation that we may not have enough adjudicators in the region. This discussion, of course, translates then to the panels. I think more and more we are considering that developing these panels in a way that they're not just within one jurisdiction, but they can serve a multiplicity of jurisdictions. So we have been in discussions with our colleagues from Uganda and from Zambia, and just to mention a few countries where we have a strong Ciarb presence, on how the panels that we develop could serve on a continental level. At the moment, what has tended to happen is by default, the cases that come to us, the requests, they're mainly ad hoc requests for appointment of an adjudicator through the FIDIC forms of a contract, are normally handled by persons from the built environment or arbitrators who've got a strong experience when it comes to construction disputes. So I think in sum, that sort of gives you a picture of what's happening in our jurisdiction. And yeah, we can say, I think, just to latch on a few comments that have been made earlier, that we have a state of ADR survey that we do every 2 years. And it does show that adjudication is has a strong preference from the users on this end. And while you have the pay now, argue later principle, and you do have it being a contract based and with linkages with arbitration and the courts, and that there are very few instances where a lot of the decisions end up going all the way to court and being a challenge. So that is a very, very good thing. I wouldn't say as much when it comes to arbitration. I think we have in recent times seen a surge of challenges going to court. And that trend looks like it's going to start changing with the capacity that we've built amongst the judiciary in terms of understanding the spirit, the principles behind arbitration. But adjudication has done very well, not, I think, because of practice and not necessarily because of restraint. There is nothing outside, unless it's inhibited by the contract, for the parties lodging a dissatisfaction and then proceeding to the next stage, which would be arbitration, or in the absence of that, straight to court. However, we have generally very few de novo linkages where even when a higher platform is called to look at the dispute, that it's opened afresh on merits. Most of what tends to go to arbitration would be around the question of liability and so forth. So I hope that Cesar gives you like a very quick overview of what's happening in the Kenyan jurisdiction. Yeah, and if there's anything I may have left, I'm happy to add on to that. I just need to mention that the conversations we're having about dispute boards and their replication in other sectors is a very real one that we're experiencing here, specifically in the energy sector, how they can play a strong role. And then that the principle behind adjudication is used in other sector as for work that's sometimes within a limited scope in terms of value, and but with the same idea of expediency. And one such sector is with the small claims, where the exact phrase adjudicator is used. So it's not in the construction industry, but the idea of running fast, expedient processes to resolve disputes is leveraged for low value claims. And then again, the phrase also tends to be used from an administrative basis in the land sector. So we have land adjudicators, but it's very much within the structure of administrative law and not necessarily the way we would use it in construction adjudication. Thank you very much. If there's anything, yeah, we can still keep the conversation going. Thank you.
Thank you, Kenneth. This was very comprehensive, very, very informative, and I do have a point that I would like to raise with you. You mentioned the benefits that we would have having panels of adjudicators comprising professionals from different jurisdictions, and that is a point that to me resonates. The idea that we should have more diversity, geographical diversity, in on those panels. But on the other hand, I understood that you mentioned that while the UK adjudication is very much centered on the Housing Grants Act and on what James and Kirsten described, adjudication in Kenya is much more contract based, and it might become statutory. You said that by next year maybe we will have in Kenya a statute regarding that. But my question, very objectively, is how interchangeable the expertise and the training on adjudication is between the jurisdictions where adjudication is practiced. Do you have any opinion about that? I'm just
yes, yes.
afraid that I think we lost Kenneth, right?
Yeah, I think there are two, I think, components to how adjustable one would be from one jurisdiction to the other.
Thank you, Kenneth. I think sorry, Raphael from Arbitration Channel. I think where it's the other Kenneth that's talking. Yeah, please. Thank you.
Okay. All right.
Ahead,
okay.
Yeah.
Okay. I'll proceed. So I think my observation is we already are using adjudicators from other jurisdictions who come to Kenya to handle specific disputes, either as a standing. We also use them in the context of dispute review boards. That's another psychology and philosophy altogether. They also come from other jurisdictions. I think it's a good thing in the sense that given the relatively low number of adjudicators in this area, and given the interaction that many of these adjudicators may have from a professional service point of view, some of them could be architects, engineers, on very unique projects. the potential in certain cases, because of the different hats they wear, for conflict of interest to arise is quite real. So I have been an advocate for the idea of growing the basket or numbers of adjudicators and where you could bring them. If you think using the language of dispute boards and specifically the avoidance elements, I think the idea of mentorship to understand the unique contexts in which many of these public infrastructure disputes are occurring, sometimes where they interface with communities, and what you call the democratic culture of certain jurisdictions and how that sort of operates. I think it's important to have, where possible in some of these courses, some transition into those local dynamics. There will also be the local legislation, statutory legislation, as well as like I'd mentioned, the JBC contracts, where you may have very local contracts and administrative bodies that are in a specific country. But it would help for the training to allow for a transition to understand those dynamics. But all in all, I think in a relatively young and growing area, a platform like this, I think having a wider base that's beyond just one region would be seen as a good thing by the policymakers, provided all the other advantages are maintained, which is really cost, speed, and so forth. I hope that sort of, yes. Thank you, Cesar.
Thank you. That was great. Thank you, Kenneth. And now we go to our other Kenneth Akampurira from Uganda. Kenneth, I think that's going to be a good segue from what Kenneth Wyne was saying. How do you see adjudication in Uganda, and especially the enforcement of adjudication decisions in Uganda in comparison with Kenya, South Africa, maybe other jurisdictions that you may be familiar with? The floor is yours, Kenneth. Thank you.
Thank you very much, President. I represent the Uganda chapter as honorary secretary. I think I'm the only chapter who's appearing today on the talk on the channel. But thank you very much. And also, traditionally, we have a saying that when the elder has finished speaking, you don't want to speak because you might contradict the elder. So thank you very much, Professor Wyne, for going before me as my branch chairperson and president. Thank you. But yes, I'll take it up from the president's question on enforcement. I think Uganda comes at, we are the infant stage, if I put it that way, in terms of adjudication and enforcement of decisions of the adjudicator. I speak very comfortably because of my master's degrees in construction law and specializing in adjudication specifically. So my thesis is about Uganda, Kenya, South Africa, and Singapore. Of course, plus drawing also excerpts from Australia, those that have adopted the UK model of statutory adjudication. While it might be very, I don't want to say simple, on the side of the UK and Australia and Singapore that have already gone the statutory line, arising of the LATMA report, it is difficult in Africa or even in Uganda for you to begin introducing an enforcement. Not difficult in the sense of the filing into court, but even harnessing the idea of that an arbitration or an adjudication award is binding on the parties. So I think we start from a point of number one, do we appreciate that the adjudication decision or award, if you want to put it that way, is actually binding on the parties in the interim? before you even proceed to adjudication, because it has timelines. So whereas we may have an issue of a knowledge gap between us and mainly those in the litigating forum, there has been also notable progress on what the courts will actually enforce when it comes to an adjudication award or even an arbitral award. So our jurisprudence has transcended, number one, on recognizing that there are ADR decisions that do also come into play, especially in the construction space. So what is happening is we are very much appreciative of the fact that our judiciary has embraced. We have a very new decision on from our commercial court by Justice Odong. That's in Plan Build Technical Services Limited versus the Attorney General. That decision is a 2025 decision. And one thing that we must applaud our courts for is for embracing enforcement of decisions arising out of adjudication or decisions arising out of arbitration. So this decision recognizes the fact that parties are bound, number one, by the contract that they have executed. So if the decision, or if parties are undergoing adjudication arising out of a contract, that is in our jurisdictions where we don't have such an adjudication or even anything to do with the enforcement of adjudication awards, courts have embraced the fact that parties are bound by what is in their contract. So whether you have the standard form contract, like in Uganda, we use the PPDA standard form, which is the Public Procurement and the Disposal of Public Assets Act. There is a standard form contract that arises thereunder. And that contract in itself provides for adjudication as the first place or the first tier for any dispute arising out of any construction claim or any construction dispute. So at least in this decision, courts have embraced the fact that parties must be bound by the contract. So courts are not willing to touch these contracts anymore. It more or less also borders on the FIDI contracts, because Uganda heavily lies on infrastructure funding for most of our projects, the infrastructure projects like the roads and bridges. So the FIDI contracts have also been embraced in our jurisdiction, and the dispute resolution clauses have also been embraced as binding on the parties. So the courts have totally pushed parties to go back to the known procedures in the contract, which are adjudication, arbitration, or if you had mediation first, and then the enforcement of the arbitration award. Our courts have also been very clear on enforcement of an arbitration award. For as long as there are no grounds for setting it aside, the award must be enforced 100%. So leaning on Uganda, and first in terms of the region itself, so Uganda and Kenya, we've seen less enforcement or less challenges of adjudication awards in our courts. Off the record, for Uganda, we have only one decision that went all the way to court. It was an adjudication decision. The only dilemma that the decision faced was that the parties who went to court, or the successful party who went to court, did not go for enforcement of the decision, but instead went for an enforcement of the adjudication award as if it were an award, final and binding on the parties. Yet an adjudication award is in the interim binding on the parties until when it's challenged under arbitration. So the party jumped the gun of arbitration and went to enforce the adjudication award as if it were final and binding. However, we have criticized the mode in which the case was brought to court. In our view, we felt that if the party or the claimant had brought the claim as enforcing an adjudication decision on the basis that the other party was out of time, because our PPDA standard form contract provides for a timeline within which you can challenge a decision. So if 28 days have lapsed and there is no notice of dissatisfaction from the losing party, that should be final and binding on the parties. So it should be enforced as a contract arising out of the agreement of the parties to be bound by an adjudication award if 28 days lapse. So the other party instead chose to enforce it as a final award in arbitration. So of course the judge could not award them or enforce the decision as if it were an award, because the party had not come to court with such a prayer. We believe that would have been different. We're now looking out for an opportunity where we can now file a summary suit or a special endorsed plaint. That's in the UK jurisdiction. I think that is well appreciated in terms of a summary suit. So you need not bring fresh evidence on the enforcement of that suit. So we are looking forward to an opportunity when we can file a decision of an adjudicator or a DAB in our commercial court for recognition and enforcement, because time has either lapsed, the 28 days for challenging the adjudication decision, or by way of a full and final entitlement to the successful party because of, again, lapse of time for challenging. At least for Kenya, they have challenged one. There was an attempt to challenge, and there's a decision of Sogea. In that decision, I think it's still on. I think it's still online. I could get the parties right. It's Sogea Santon versus the National Irrigation Authority. It's a Kenyan decision which embraced the enforcement of an adjudication award as binding on the parties, owing to the fact that they have chosen their mode of dispute resolution to be adjudication first and then arbitration. So where lapse of time arises and you cannot proceed to arbitration, parties are bound. So we are seeing a traction from, and in the Sogea decision, the trial judge relied on decisions from South Africa. There's a very interesting decision in South Africa of Tabular Holdings Limited versus DBT Technologies Limited, where the judge, all the way till I think the appellant court, they have all enforced the adjudication decision arising out of a DAB. That's the district, sorry, not district, the dispute adjudication board. So the enforcement of a DAB decision in South Africa is quite now well laid down by virtue of the jurisprudence in terms of the many decisions that have been churned out by the courts, especially their commercial courts, all the way to the Supreme Court. So in Kenya, the Sogea decision wholly dwelt on the jurisprudence down in South Africa to demonstrate that these authorities are persuasive, even if they come from the from the southern region of Africa. They were persuasive in Kenya. Now that we have a decision in Kenya, in Uganda, it will not be a difficult one, in our view, to cite the same from a Commonwealth jurisdiction, which is Kenya, sister jurisdiction, and they will be also seen as enforceable. So we are more eager to ride into the enforcement if any claim comes. But I also want to touch on the aspect of Kirsten. Kirsten raised she's given a platform of training and passing on these skills to other adjudicators or those who are intending or who aspire to join. I would say that in Uganda we have made substantial footsteps in terms of being a young chapter. We are, I think, just 4 years old. I think coming to 4 years old, but we have encouraged all our membership to abreast themselves with construction disputes, adjudication and arbitration, the required standard of acting as an adjudicator or even representing a party. Many of our members have now enrolled for the FIDIC trainings, which are on the FIDIC website, also as a way of capacity building on the side of Ciarb members. There's also a partnership with the Construction Law Institute of Uganda, which also churns out a number of trainings, specifically on the FIDIC suit contracts, and also on the PPDA, which is our local one, and also best practice in the market. So principles of adjudication are now being inculcated into our, number one, the build, and also the legal fraternity. Our Law Society has also picked up the construction law trainings, which is a way of capacity building for our region, number one, but also for the membership of Ciarb. Ciarb, at the time of setting up our chapter, our president, Professor Wyne, together with the past president, may he rest in peace, were very emphatic on the membership of Ciarb, that we need to diversify Ciarb from lawyers to also include the build community. I think we took that lesson with all hands out, and we have embraced enrolling more of the build community, like quantity surveyors and engineers, into Ciarb. We were less than 20 at the time of our formation, I would say, but right now I can assure you we are close to 240 members, some of whom are fellows of the Chartered Institute of Arbitrators. So in terms of capacity building, we have done steps, or I think I'll not say steps, we've done strides into that direction. Yeah. I think I'll end here because I see my time has run out. I think I'm 16 minutes now into my time.
Thank you, Kenneth. This is all very exciting and very engaging. And I remember earlier this year when I had the opportunity to come to Kampala, and we met the Uganda chapter members, and we met on a Sunday actually, and lots of people were there, and it was really exciting to see all the energy in Uganda, and what you described about adjudication is not different from what I saw there in person. Thank you so much. And I will now transition back to Europe and talk to Brandon about the situation in Scotland. And I understand that, Brandon, there are interesting things to discuss about how arbitration or adjudication works in Scotland in comparison with England and Wales as well, in what we have been hearing about Kenya, Uganda, South Africa. I would just ask you to do me a favor. There is a question from the audience coming from an architect who asks specifically about the boundaries between arbitration and construction adjudication. I think Kenneth now has just touched on some of them, but as you talk about your topic, if you could please explain that more objectively so that we can resolve this question here. Thank you, Brandon.
Thanks, Cesar. Yes, I'm in Scotland. To be clear, Scotland is still part of the UK, at least meantime. It's a live question. But we heard about the UK earlier, but the UK, when I think we're focusing on England and Wales. That said, the position in Scotland is very similar. It's the same legislation. I should just explain who I am. So I'm the immediate past chair of the Scottish branch of the Institute. I'm an advocate and a barrister. I'm also a chartered surveyor. And I was involved in one of the first adjudications under the Act when it came in 1998. I started taking adjudicator appointments. I think my first one was 2015, but more regularly around 2019. And I've done between 50 and 60 of them now as adjudicator, having represented parties as counsel in many cases before that. And I'm on the various panels. So I'm on the main Chartered Institute panel. I'm also on the Scottish branch panel. We have a separate panel. I'm on the RICS panel, TEXA, TECBAR, CIC, UK adjudicators, and the Faculty of Advocates. And I'm also a FIDIC certified adjudicator. And I do cases in England and Wales as well as in Scotland. So I have a better perspective on these things. I'm also an arbitrator. I set up and chaired the Scottish Arbitration Centre for many years. So I'll come on to this question about the boundaries, the distinctions between adjudication and construction. So we've had adjudication in the construction industry in Scotland since '98 when the Act came in. And really it was immediately adopted as the default dispute mechanism in construction disputes. And I would really echo what James was talking about. There are many reasons for that. I think there's the speed is probably the main one. When you compare it with litigation and arbitration, it's a much faster process. The point that you asked about, Cesar, about not getting your expenses, it's a very interesting one because, as you say, if you're in the right and you have a claim and you're going to have to spend money to get your money back, then you might think, well, the fact that you can't recover expenses would put a party off. But in fact, the opposite has been true, we found in adjudication. And that is because I think parties like to know that they're completely in control of how much they spend on the process. Yes, they won't get that back, but they know that they're not risking a massive award of legal expenses coming back their way. Yes, if they lose, they will have to pay the adjudicator's fee, which can be substantial, but it really does limit risk in a way you can't do with litigation or arbitration. So it's been extremely popular. It really, we had a limited amount of construction arbitration in Scotland, and really it more or less put an end to that for a long time until we refreshed our legislation. And even now, adjudication is really the first port of call. What are the differences with England and Wales? Well, the Act is the same. There are regulations under the Act called the Scheme for Construction Contracts, and we have a different one in Scotland, but it's almost word for word the same. We have a different legal system. We have different courts in Scotland. We don't have the TCC and the procedure under the TCC for enforcement. The method here, by and large, is that you go to the commercial court in the Court of Session, which is our equivalent of the High Court. They have a very rapid system. Essentially, you get a reduced period of notice and 7 days or so, and then the defences come in 7 days after that, and then the enforcing party can put in what they call a motion for summary decree, and the court will deal with it on a very speedy basis. In terms of how you can challenge these things, again, the same as the position in England and Wales, is really only if the adjudicator has acted outside of their jurisdiction. So if they have answered a question which was not put to them, or if they have perhaps dealt with a dispute that's already been decided under adjudication. So there's an excess of jurisdiction, or if there's a breach of the rules of natural justice. So if the adjudicator is biased, or if a reasonable person would have thought they were biased in how they behaved, then that can be a ground of challenge. But by and large, challenges are rare. Successful challenges are very rare indeed. I think it's also true to say that adjudication tends to be the last stop in the process. It is pretty rare for parties to continue and go to court or arbitrate. That said, I know that there have been a few cases that where there's been a lot of money involved, recent decisions where the decision of the adjudicator hasn't been challenged, but the parties have gone on to court and have asked for a final decision. And sometimes the court said, yes, the adjudicator was right, and the parties remain where they are. And sometimes the court has taken a different view and said, well, we don't agree with the adjudicator here, so we are going to effectively award repayment of the money. That's not the same as a challenge. It's not overturning the adjudicator as such. It's simply looking at the thing afresh and then dealing with the financial consequences of that. In terms of procedure, the procedure is pretty much the same. There are cultural differences, perhaps, arising out of the different legal systems. So, for example, in Scotland, it tends to be the case that you have a referral, a response, and then a reply to the response, and then a rejoinder, so that the defending party gets the last word. Whereas in England and Wales, it tends to be the party making the referral that gets the last word, but none of these things are cast in stone. I think historically there was more of a pattern of having a hearing in Scotland than there was in England and Wales, but again, I think that is perhaps shifting, and we see fewer and fewer hearings and things just dealt with on the paper. The courts, as I say, are very supportive, and we do see that some of the cases that have fed into the general thinking on adjudication and enforcement have come from Scotland. So Scottish cases do have a resonance UK-wide. Just to look at other dispute processes. So we talked about dispute boards. The dispute boards have their own adjudication process, an 84-day process, where in the UK, statutory adjudication is 28 days. But the factor there that is more difficult to cater for is that if you have a UK project, you have a right to go to statutory adjudication, regardless of what the contract says. So if you have a modern FIDIC contract, you may have a dispute board in place from the outset. They may be trying to help and avoid the dispute, or you might have got to the point where there's this 84-day adjudication process. You may have asked for a view on things. Any of the mechanisms there, because you're in the UK, you can cut across all of that with a statutory adjudication application. And that is something which NEC contracts, for example, are now catering for. But with FIDIC, you still have that possibility that you have to contend with. So a possible spoiling tactic for dispute boards. With arbitration, of course, there are many differences. If we think about, first is binding effect. Adjudication is binding only on a temporary basis. Arbitration is binding on a permanent basis and is very difficult to appeal. Arbitration will generally take a lot longer, but does have that more final effect. The thing about adjudication is, although it's quick and relatively cheap, and although most people do take that as the end point in the process, because as James said, you've had your day in court, obviously not in a real court, but you've had an airing of your dispute, a neutral person has decided, so you tend to go away. But that's not always the case, and unless your contract says that a decision becomes binding finally, then it can carry on, and you can get to the arbitration or litigation stage. Not the case with arbitration. When you arbitrate and you get an award, then in most jurisdictions, that's it. There are very limited grounds for challenge and almost never a way to appeal the decision. So that finality is a distinction. Another distinction between arbitration and adjudication is that arbitration in some jurisdictions, not all, certainly in Scotland, arbitration is a confidential process. And then if you spin off into court to enforce it, or challenge it, you have that confidentiality and anonymity preserved, which is not the case with adjudication. It is a private process, and it's confidential in a sense, but if it ends up in the courts, it all becomes public. So that's the distinction. The costs, obviously, with arbitration, you have the ability to recover costs, but you also have the exposure to an adverse award against you if you lose. I think those are probably the main main distinctions. Arbitration is obviously a much longer process with an opportunity to get far deeper into the facts and the law than you can do in the very restricted 28-day process of adjudication.
Brandon, if I may just ask you a quick question.
Yes.
I thought it was really interesting what you said about when you have dispute boards on the contract, you could still, in the UK, resort to statutory adjudication. And can you just like very briefly explain how they interplay with each other? Like, do you have like 2 bites? You try the adjudication. If that's not good, you go to dispute board, or if you resort to an adjudication that would override or supersede somehow the dispute board provision. How does that work in practice?
Well, it doesn't. I think this is the issue. It doesn't work in practice. The problem with the UK Act, or the advantage, depending on your point of view, is that you can go to adjudication at any time. So you can be in the middle of a mediation and receive an adjudication notice. You can be in litigation and receive an adjudication notice. And certainly I have done a couple of adjudications as adjudicator when I know the parties are litigating it. And sometimes they're doing it purely tactically. And I've done it myself, I have to confess. I had a big claim about a distillery that was sinking. It was unfortunate. And the other side were sort of stonewalling, and it was a professional negligence case. And we raised an adjudication, and we flushed out a lot of material. We won the adjudication in the event, which was great. But then the litigation carried on, and the adjudicator's decision got overturned on a technicality. This is quite a number of years ago when the courts were more open to challenges to adjudicators' decisions. I'm not clear it would have happened now. But there's a tactical advantage in taking an adjudication. So how does it work? It doesn't work terribly well with particularly a DAAB procedure, which is meant to avoid disputes and have the project go along peacefully, if at all possible. It's there to get a quick determination. And that determination is binding on the parties until it's overturned by litigation or arbitration, or superseded rather, not overturned. How does that fit in with a FIDIC contract, for example? Well, not terribly well, and I suspect I haven't seen a case where those two things intersect. I'm not sure if there has been one, but obviously they don't fit terribly comfortably together.
Thank you. Well, this was wonderful, and one more angle for us to think about this this variety of issues. Thank you, Brandon. And I would like to turn to Corrine, who is also from Scotland, and I know she is involved with the appointing and training of future adjudicators through the Scottish branch. And so Corrine, if you can tell us a little about that, and I would be very much interested in hearing you also on what you think about this geographical diversity. How much would, for instance, Scotland-trained adjudicator be able and willing to take on adjudication appointments in Kenya, Uganda, South Africa, other jurisdictions where that exists, and vice versa? What do you think about training, specific training for advancing diversity? Corrine, please.
Hi there, good afternoon everyone. It's a genuine pleasure to be part of the session today, and also to hear perspectives from across the jurisdictions. I'm deliberately going to step away from the legal side. So I think James and sort of Brandon has touched on that quite well already. I'm going to touch on some of actually Kirsten's comments about training and obviously what we are doing as a branch as well to improve diversity. I want to give you a sense of how adjudication sort of actually works in practice, and also what we're doing as a branch to support that. I'm going to draw on my experience in adjudication and hopefully give you a practical perspective. So a brief introduction to myself is I'm Corrinne McLeish. I'm currently a director with HK Global Limited. I am a chartered quantity surveyor. I have been now for 22, 23 years now. I am a member, a fellow of the RICS, and from last month I am also a fellow of Ciarb. I have been focusing in on dispute resolution now for the past 8 or 9 years. I did my LLM about 10 years ago, and probably about 4 or 5 years ago, I took more of a special interest in adjudication, and so much so that I finished my diploma in adjudication, and I have just very recently taken on my first couple of adjudication appointments. So I'm obviously coming to the talk today as very much a freshly qualified adjudicator, and as Kirsten sort of talked on as well about getting more appointments, getting on to more of the A&Bs also. As James touched on earlier, also adjudication, particularly in Scotland also, is very much part of the normal construction toolkit for resolving disputes. It's not an unusual or exceptional form of dispute resolution. Now it's very much the norm in Scotland. It's fast, it's accessible, it keeps projects moving. I would say also that low value disputes are also on the increase more now, which is now great because it's now more accessible to smaller businesses. So smaller construction companies who perhaps wouldn't have borne the cost of adjudication because, you know, they are a smaller business, so it's much more accessible now, and a lot more of the A&Bs have now specific low value dispute panels, which is great to hear. In terms of appointments, so what we're doing as a Scottish branch, so the Scottish branch is actually an adjudication nominating body for the purposes of the scheme for construction contracts in Scotland. So we play a key role here, acting as a nominating body. So we maintain a small panel of experienced adjudicators, and that's particularly important because we need to have a wide skill set of adjudicators. So we also have architects, engineers, quantity surveyors, lawyers on the panel. But it's important that we do have a diverse panel. We also have a great skill set, and I think it was Kenneth mentioned earlier, previously the panels were very lawyer heavy. But now we are diversifying that panel, and we have a robust system of making sure that we are interviewing candidates from a diverse background to make sure that we've got a great panel on there. The parties also can consider when they're raising an adjudication, in terms of that adjudicator, you know, who is that adjudicator? Do they have the necessary skills? Do they know, can you understand the dispute? And that's obviously very important that we have a panel that is basically fit for purpose. Kirsten's mentioned briefly, we have a robust process in terms of you have to be a fellow of the Ciarb to get onto the President's panel. There is obviously an interview process as part of that. Once members are then accepted onto the panel, there is further training that happens. Obviously, everybody needs to carry out their CPD every year and maintain that. We do have a minimum guidance on that. Part of that is also going to networking events. We actually just very recently, a few weeks ago, held our annual conference in Scotland. The key topic was on AI. It was very well attended, and it was great to network with a few colleagues there as well. And just talk about also what we're working on, and that is a key aspect. Adjudication can sometimes feel a bit of a lonely process, so it's great just to sort of catch up with colleagues. Obviously everything is confidential, but it's great just to sort of catch up with colleagues and just talk about any issues that we've got, how parties have acted, etc. So we need to have confidence in the system that we have a credible panel. It is robust, and we're also developing those adjudicators. A major focus of the Scottish branch is developing that, what we're saying is the next gen of adjudicators. It's important that we have a strong panel of adjudicators, so not only the Scottish branch, but the wider branch also. We need a sustainable pipeline also for the future. So it's important that we do have a good panel today, but also we're building on that panel. So we run two schemes as part of the Scottish branch. We have a shadowing scheme for adjudicators. The shadowing scheme, I would say, is for less experienced adjudicators. So it's perhaps for professionals who have done who perhaps have done a course. So they have the training aspect, but not the practical aspect of adjudication. So the shadowing scheme is specifically built for those people. They will be still in a live adjudication environment. The adjudication will be essentially run 2 weeks behind. So the adjudicator will still be doing the live adjudication, but the adjudicator's directions to the parties will then be sent to the pupil. And the shadowing scheme is purely a sort of information just to get that practical experience, how they have dealt with the parties, how they communicated with the parties, the timescales involved. So that's a great initial part of that experience for somebody who has maybe just come fresh out of training. The other scheme that we have is then the pupilage scheme. So it is again, it's a great next step for somebody who has perhaps then done the shadowing scheme and thinks, great, I've got perhaps enough confidence then to perhaps run the adjudication. So it's set on the same basis. A live adjudication, it is run 2 weeks behind with the adjudicator. The adjudicator will send the initial communications to the pupil, and then they will actually then get the pupil to say, well, how would you deal with this? What would your directions be? So essentially you would then be running the adjudication, not in a live environment. And that's great, as it's also a great practical tool for that pupil, because it gets you thinking also, if you were in that real live environment, the timescales you've got to think about, perhaps there might be challenges to adjudicator's jurisdiction. How would you respond to that? So it's also a great practical experience that we run. There is no, so when we do these two schemes, there is no guarantee that you then also get onto the panel, but it's certainly a great stepping stone, great experience for you as a pupil to then apply onto the panel. So that's actually in the stage that I'm at just now with the branch itself. I have finished my training and I'm on another A and B panel, and I am currently doing pupilage. I'm going to be doing pupilage with the Scottish branch very soon, and obviously the aim is to then get on to the Scottish branch panel and obviously the wider panel, the wider president's panel. But it's really important that we have experienced panel members who have practical knowledge as well as the training and sort of theoretical knowledge. Adjudication is fast, it's intense, it requires decisive judgment. So these schemes that we run as part of the Scottish branch definitely helps bridge between the learning and that application. It's really critical. It also reinforces that there's no single route into adjudication. As I said before, practitioners come from technical, commercial, legal backgrounds, and that diversity is a real strength to the panel. In terms of diversity, as we know, construction is very male-dominated, and we have also made great steps to improve that. There's clearly still work that needs to be done, and it's very much the same in adjudication. I think Kirsten and James briefly mentioned the paper already. The King's College paper reported that there was only around 7 to 8% of adjudicators that are actually female, which is quite a stark figure to hear, but it's also not unexpected in the construction industry. And as someone sort of relatively new to the field, it is noticeable, but we are also making steps of growing awareness into that, and there is a willingness to address that, which is obviously great. The work that we're also doing in Scotland through the mentoring and pupilage scheme is one of our ways to also address that, also open up access and clear those entry routes. But we do need more visibility over female adjudicators, but equally those of our male allies and our male adjudicators. The pupilage that I have done so far have all been done by males. I wouldn't be here today without their support, without their mentoring. The ultimate goal is also to inspire and build a younger generation, and that will come from being more visible as a female adjudicator, but also from our male counterparts. I think we've made significant steps in that, but it's essential that we widen participation and also encourage more representative mix of also professionals in the industry. Another initiative that we have that I'm involved in within the branch is our newsletter. So one of the initiatives that we've developed and will hopefully be getting out soon is we are going forward. We are now going to spotlight our panel members, which I think is also a great initiative, and it sort of seeks, it makes confidence in the public who are going to need or who want to appoint an adjudicator within the branch. Who are they? What is their background? And their experience. Sometimes I feel like you're in a catch-22 with these things, because you need appointments and you need experience, but then you can't do that because some parties will want that experience, and it's difficult, and that's why I think with the pupilage and the mentoring, and just keep on working towards that is a great step. It's also great to see that the Ciarb already is a is a signatory to the various number of pledges. Obviously the equal representation, an arbitration pledge, women in adjudication pledge also, and they're also a steering group for the equal representation of expert witness pledge. And I think these are great initiatives, and we need to be more visible in doing that. Another part of the branch that I'm involved in is our young members group. I'm not sure if all branches have this. We certainly do in the Scottish branch. Young member is still to be defined. You know, you obviously feel young at heart. You guys will hear it first. So as an exclusive, we are going to also, we've just ran a webinar just very recently, just last month. We did an introduction to arbitration, and we have now got a speaker lined up and some dates lined up just this morning actually. So we're going to hold a 2-part series in August and September. So we're going to hold, as part of the branch, an introduction to adjudication for our young members group, and then also for our speaker who has been an adjudicator for the past 20 years. He is also going to be speaking about his experience in adjudication and his suggestions on how we can also improve the process in adjudication. So it'll be really good to hear his thoughts on that. Yes, I think that's all I've got to say for now, but if you've got any questions.
Thank you, Corrine. It's really wonderful to hear that all the work that you have been doing with regard to diversity, and I hope in a short time that will reflect on the presidential panels of Ciarb as well. As you described, if you are a fellow and you qualify, you can apply to be on the presidential panel, which also will benefit tremendously from greater diversity in all aspects, gender, age, geographic. I think all of those aspects are important, and it's very good to see how the Scottish branch is working on that. And I completely agree with you, and I saw that in Kenya when I was there earlier this year. Mentorship, pupilage, those are all the essential tools to increase diversity in a meaningful way, and to engage people from various backgrounds to be really involved. So thank you so much for sharing that. And I would like to ask Dermot Durack, who is from the Irish branch, for his view on this idea of an exchange of professionals across the jurisdictions that work with construction and adjudication, and how things are in Ireland with regard to that, and other aspects of the topics we're talking about. So Dermot, please, the floor is yours.
Thanks very much, Cesar. Dermot Durack is my name. I'm a chartered quantity surveyor and non-practicing barrister at law. I operate as an adjudicator here in Ireland and a party representative as well. And I suppose it's probably because we're all English speaking, I have done party representative in England. I've also done a little bit in Scotland, and actually Brandon is enforcing one of my recent adjudication wins in the coming weeks. And we do have a number of adjudicators from the UK that operate in Ireland as well. So there is a good bit of cross-pollination between the Irish and UK jurisdictions. This year we're celebrating 10 years of adjudication in Ireland, because the Act came into force in 2016, and I'm going to discuss the evolution of the construction adjudication in Ireland, the impact of the Construction Contracts Act, and some recent jurisprudence, just look at one or two cases. So the introduction of statutory adjudication under the Construction Contracts Act represented one of the most significant reforms in Irish construction law in recent decades. Like other jurisdictions, it was designed primarily to address chronic cash flow issues within the construction industry following our economic crash around 2007, which saw a lot of construction firms fall into financial difficulty. The Act established for the first time a statutory right to refrain or to refer certain disputes to rapid and binding adjudication processes. And we already had some contract adjudication because it wasn't uncommon for UK clients to use maybe the JCT or UK contracts that had adjudication in. So we had a little bit of contractual adjudication, but it came in on a statutory basis in 2016. And although it has been long embedded in jurisdictions such as England and Wales, it is relatively recent to Ireland, only coming into effect, as I said, in July 2016. And this means that its development has been gradual and heavily influenced by judicial interpretation over the past decade. Irish courts have played a central role in clarifying the scope, purpose and limits of adjudication regime, and I'll go into them shortly. Today I'll examine the evolution of adjudication under the Act, the emergence of key judicial principles and the implications of recent High Court decisions, particularly tender bids and Connaughton, before considering how the Irish regime compares with other jurisdictions. The Act was enacted in response to concerns about payment practices in the industry, which had, I suppose, deteriorated under the economic crash, particularly the adverse effects of delayed or withheld payments, or payments becoming dependent on payments from others. Its primary objective was to ensure a steady flow of payments through the contractual chain by providing swift and cost-effective dispute resolution mechanisms, and also introducing the statutory right of suspension. Under the Act, parties to a construction contract are entitled to refer a dispute relating to payment to adjudication at any time, and I'll come back to that relating to payment later. The adjudicator is required to reach a decision typically within 28 days, just like the UK, and that decision is binding on an interim basis unless and until overturned in litigation or arbitration. Enforcement of adjudicators' decisions is facilitated through summary procedures before the High Court under Order 56B, reinforcing the principles that adjudication is intended to provide immediate and enforceable outcomes. Unusually, the Act was introduced through our upper house of Parliament, known as the Shannon. I suppose it's our version of the House of Lords. Usually, legislation is enacted through the Dáil and I suppose rubber stamped by the Shannon, but this went the other way around. So I suppose it's like our version of the House of Lords, but the senators are elected by universities and industry groups. It's only 60 senators as compared to 174 members of Parliament. And this Act was introduced by Senator Fergal Quinn, who was actually a supermarket owner, as it happens, not from a construction background, and Sean Gallagher, who was from a construction background, and he was actually one of the dragons on our version of Dragon's Den, a popular TV program, but he did come from a construction background and had seen the devastation caused by poor cash flow in the construction industry. Just looking to the initial uptake of adjudication in Ireland, it was relatively slow. Conciliation is still very popular here in Ireland, and this slow uptake can be attributed to a lack of familiarity with the process, cultural caution amongst industry participants, and the absence of an established body of case law to provide certainty. However, usage has increased steadily in recent years, with the number of applications for adjudicator appointments rising year on year. And disputes of significant amounts have been referred to adjudication. Now, there has been a little fall off in the last 6 months, but I'll come to that later. So approximately, we have about 90 appointments every year and maybe 10 or 20 by agreement. Obviously a lot lower than the UK, but we have a much smaller population and smaller GDP. In its early application, the Irish courts adopted an approach broadly consistent with the established UK jurisprudence, emphasising the pay now or argue later philosophy. Courts demonstrated a strong willingness to enforce adjudicators' decisions, limiting intervention to cases involving a lack of jurisdiction or breaches of natural justice. This approach is evident in decisions such as Principal Construction versus Benevin, where the courts confirmed that the statutory right to adjudication could not be contracted out of, and that adjudicators' decisions would generally be upheld. Just looking at the scope, because our Act says disputes relating to payment as opposed to disputes. A defining feature of the Irish adjudication regime is its statutory limitation to disputes relating to payment, unlike broader regimes elsewhere, and the Act does not permit adjudication of all types of construction disputes. This limitation has given rise to considerable uncertainty and debate, and central questions emerge as to whether the phrase should be interpreted broadly to include any financial disputes, or it should be confined to contractual entitlements to payment. The resolution of these issues has become one of the most significant themes in the evolution of Irish adjudication jurisprudence. From 2020 to 2024, we had a steady growth as adjudication became more widely used. I suppose in the first couple of years after 2016, there was probably only one or two, but I suppose you had to wait for contracts to be awarded post July 2016, then work through the process and come to dispute afterwards. So during the initial couple of years, there was very few, but then it started to grow. During this period, the judiciary continued to support the statutory scheme, reinforcing the principle that adjudication decisions should be enforced swiftly and with minimal judicial interference. Nevertheless, underlying tensions began to emerge, particularly concerning the jurisdictional limits of adjudicators. These tensions would ultimately crystallize in more recent case law. So we've had 20 written decisions in adjudication cases in Ireland, and all of them were enforced except 3. So there's only been 3 that have been rejected. That's 20 written decisions. We've also had a few more where maybe they haven't been contested or they haven't been reported. So the 3 cases we've had have been tender bids versus electrical waste management, number 1, Albert Connaughton versus Timber Frame Projects, and then tender bids versus electrical waste management, number 2. The majority of these decisions have been handed down by Justice Gareth Simons. In Ireland, again, we don't have a TCC like the UK, again, because we don't have the same caseload. So the Irish approach would be to appoint specialist judges. So we've Justice Simons deals with all the adjudications. And then, for example, Justice Barnable deals with all the arbitration decisions. So that's what they've become a mini TCC in their own right. Unluckily for tender bids, you'll have noticed there it said tender bids number 1 and tender bids number 2. We've only had 3 that weren't enforced, and 2 of them arose out of the one dispute. So unluckily, tender bids found themselves having 2 enforcements rejected, both arising at the one project. The first one was a technical one related to the notice not being served by registered post in accordance with the RAI contract. Our RAI contract, Royal Institute of Architects of Ireland, I suppose it's similar to the JCT in the UK, and it prescribes that notice of adjudication should be sent by registered post. In that case, it was sent by email, and the judge said the whole process was void ab initio and struck it out. So I suppose that was just a reminder to, as it says on the tin, do what it says in the contract, and be careful when you're submitting documents that it does comply with the contract. The decision, the second tender bids versus electrical waste management, however, marked a notable development in Irish adjudication law. It was one of the first instances in which the High Court declined to enforce an adjudicator's decision on jurisdictional grounds. While the Irish courts had previously demonstrated a strong pro-enforcement stance, tender bids indicated that such support was not unconditional. Instead, it confirmed that adjudication is a statutory mechanism subject to defined limits, and adjudicators must remain within those limits. Although the facts of tender bids were specific, its broader significance lies. Yeah.
Let me just ask you a question
about
what you just said in terms of statutory adjudication. You said before that there was a discussion whether adjudication was available only for payment disputes or also for other disputes. That's
the next case I'm going to come to now, which is Connaughton.
My curiosity is if you can add that to your comment.
Yeah, I'll do it.
Can parties have a contract-based adjudication in contract around any statutory limitation, or statutory adjudication is the only available adjudication? So if you can just answer that question also.
Yeah, well, statutory adjudication is the only adjudication in Ireland now. We did have some contract adjudication beforehand. Just to finish what I was going to say in that tender bids case, and when it looked at jurisdiction, the tender bids case effectively did away with smash and grab. Smash and grab, it's not a great term, it's default adjudication. If you don't issue a response, the whole amount becomes due. So Judge Simons looked at this and he decided that the way our act was written, even though there's no consequence in the act for not issuing a response, if you have a payment claim now, you have to justify the whole thing. Whereas in the UK, you have smash and grab. If you don't get a response to your payment claim notice, the whole amount becomes due. So now we only have, I suppose, true value adjudications in Ireland. So that's narrowed the scope a bit, and it's also, I suppose, a distinguishing factor now between Irish adjudication and UK adjudication. Connaughton then was the other case, and that looked at the payment disputes. And I suppose, unluckily for my firm, this is one that we were involved in. We won the adjudication and we lost the enforcement. Now, we weren't totally happy about that, so we've now taken it to the Court of Appeal, and it's the first case. An adjudication case has gone through the Court of Appeal, and we're waiting on the decision. But the High Court decision in Connaughton versus timber frame represents I suppose, a pivotal moment in the development of adjudication in Ireland. The dispute arose from the termination of a construction contract involving the design and erection of a timber frame structure. The employer sought to recover not only payments made under the contract, but also damages for breaches, including consequential losses, inflation, loss of bargain. So the employer paid 90% of the contract value, and the contractor only delivered the ground floor element and failed to erect a timber frame, necessitating the employer engaging an alternative contractor. So obviously they were trying to get their money back. It was a construction contract, it was a payment dispute. The adjudicator awarded compensation to the employer, and the employer sought to enforce the decision of the High Court. The employer didn't get all their money, but they got most of it. And then in the decision, the central issue was whether the dispute constituted a dispute relating to payment. And up to this case, everybody thought that a payment dispute, and remember the UK, if any dispute, in Ireland, we just treat the Act to say payment dispute. Everybody thought that a payment dispute was some dispute that you could put a euro sign in front of it. And the court refused to enforce the adjudication, holding that the statutory right to adjudication is confined to disputes concerning payments provided for under the contract. Claims for common law damages for breach of contract fall outside the scope of the Act, and the term payment must be interpreted narrowly. So we were arguing for a broad interpretation of payment dispute, and it kind of turned on that there was no termination clause in the contract. There was a bespoke short contract. The judge said that repayment following work not being complete wasn't covered from the contract and would have to be sued from the courts for damages. So it's quite a significant case. Again, that's narrowed the scope of it, again, not just from to a payment dispute, to a payment dispute, I suppose, contemplated within the terms of the contract. So Connaughton provides critical and I'd say unwelcome clarification of the limits of adjudication in Ireland. So you now have a narrow interpretation of jurisdiction. The Act applies only to claims for contractual payments, not to broad financial disputes. And we're not sure even what happens with implied terms, because we'd argue as an implied term that you get a refund if the work wasn't done. So the exclusion of damage claims, so claims for breach of contract, including loss of profit or consequential loss, cannot be pursued through adjudication. And it was a reinforcement of the statutory limits. So adjudication is not a substitute for litigation or arbitration in resolving complex contractual disputes. So the current position in Ireland, so following Connaughton and Tenderby's legal position can be summarised as follows. Adjudication remains a fast and effective mechanism, and the courts continue to adopt a generally pro-enforcement approach, and we're back on track at one or two enforcements since. However, enforcement will be refused where the adjudicator exceeds their jurisdiction or the scope of adjudication is not clearly confined to contractual payment entitlements. Some of the opinion that this represents a more balanced and mature stage in the evolution of Irish adjudication, combining strong enforcement with clear jurisdictional boundaries. However, others, including myself, maintained that the dilution of adjudication means that the Act is no longer doing what it says on the front page of the Act, which is an Act to regulate payment in the construction industry, because there now is no consequence to not complying with the payment provisions of the Act. So just maybe looking at some distinctions now between Ireland and the UK jurisdictions. So Ireland is limited to payment disputes, whereas the UK it's any dispute, but it must be a payment contemplated by the contract. So you've no smash and grab, so it's only true values. The judges repeatedly stated that they won't be bound by UK legislation. Maybe that wasn't so relevant 10 years ago, but when we thought our systems were more similar now, the similar systems have diverged a bit. The UK case law mightn't be as persuasive, but I suppose in your initial dispute, it might be persuasive. So we've no TCC either. We just have judges acting in a specialist manner. Another unique thing compared to the UK is we only have one panel or appointing body, and that's run by the Department of Enterprise, one of the government departments. So that's the main panel. We do have a low value panel working outside that, but you have to agree the adjudicators off that. We just have one code of practice as well, so you don't have various different rules like you have in the UK. So in the UK you have different rules for all the different nominating bodies. So in Ireland we just have to familiar ourselves with one act. We call the scheme the schedule, and one code of practice, so it's a bit more consistent. There's no time limit for submitting the referrals. In the UK, once you issue your notice, you have to get your referral in within 7 days. We can issue a notice and then take our time about having an adjudicator appointed and take our time about issuing the referral. And quite regularly that leads to without prejudice negotiations. And I think we'd have more adjudications settled on a without prejudice basis than you would in the UK, because once the notice goes in the UK, the starting gun is fired and you're off. There's other small things like our residential occupier exclusion is slightly different. It's based on the square meterage of the house, which gives you I suppose certain dynamics, because in certain exclusive parts of the city, a small house can be worth millions, and then a large house down the country can be worth a lot less. We exclude public-private partnerships, whereas in the UK they exclude specific types of project like nuclear energy. Even our 7 days is slightly different. It's 7 days in Ireland is 6 days because it's within 7 days, so you count the day in which the notice was served. Even our 28 days is a day shorter because you're counting the day it was served. So the small little tweaks like that. Now, we have seen a drop off in numbers in the last 6 months because those two cases that I referred to that did away with smash and grab and limited to payment disputes have only come about 6 months ago. So there's probably a little bit of uncertainty again, and there's been a significant drop off in cases. I referred one to adjudication last week, and it's case number 23 with the ministers panel. So that's a big drop off since last year, but maybe with a bit more clarity. Maybe if we win this appeal, it'll come back around again. But I'd say, like the UK, adjudication is deeply embedded now in the Irish construction industry. But I suppose there's still an element of the smaller subcontractors and the smaller contractors that don't know about it. So there's still a bit of education to be done so people know this there and that they can rely on it. Finally, so the introduction of adjudication in Ireland has been fundamentally altered the landscape of construction disputes in Ireland. While it was initially slow to take off, it is established now. Those recent cases have changed things a little bit, but I think that'll iron itself out after a while. I'm probably looking forward. We probably need further judicial refinement just to iron things out, and potentially legislative reform. And you had it in the UK because you have your updated act that came in I think 2011. It's very difficult to get everything perfect on the first publication, and you see how the courts react and how they enforce things. So I think we're probably due maybe some amendments to our act. There's some terms that aren't defined as well. And I think one other shortcoming is, I think initially we were very much copying the UK legislation, but then they made a few changes so it didn't look like we were copying somebody's homework, and those few little tweaks have probably caused a little bit of confusion now. So it probably is time for a little review of the Act and maybe publish some amendments in the same ways that you had in the UK when you're so many years in. So maybe that's a discussion for another time to see how you came about having your amendments. So that concludes what I was going to say today. Just a whistle-stop tour about our adoption of it, how it's evolved over the last 10 years. It is well embedded now. It is trusted, but just the scope of it has been narrowed a little bit with recent judicial decisions. So I'll hand back to Cesar now in case you have any questions.
Thank you, Dermot, and good luck in that appeal there. Maybe that will help.
Hopefully.
Yes, maybe that will help put some of those discussions back on track. And well, I would like to well, now we have come to the end of our time, and I would like to thank once more our brilliant speakers for today and all the branches that they represent. So again, thank you, Corrine, James, Kenneth Wyne, Kenneth Akampurira, Kirsten, Brandon, and Dermot. I would like to thank also Paul for all the work that he has put into preparing for this session, and it's a pity that we couldn't have him today. But it's very good to know that we are all engaged in expanding our panels of adjudicators to have greater diversity, and also learning together about the possible collaboration between Ciarb and the dispute resolution world, so that we can also expand our activities to this other realm of dispute resolution and dispute avoidance. So with this, I close this session of the Ciarb Branch Time. And I would like to invite all of you to keep paying attention to Ciarb socials for the next session that will take place possibly on the last week of June. And thank you, and see you next time. Goodbye.
Thank you.